seated, please. Sorry, we stand, Brent.
Your Honor, after further discussion, Mr. Segura has indicated he does not wish for us to put on any witnesses or argument. He's also instructed us that he doesn't want to do a Spencer hearing, request a Spencer hearing at all. So I think we need to proceed with the colloquy if that's his decision.
Okay. Well, okay. Stand up again, please, Mr. Segura. What Mr. Prince indicated, is that correct?
Yes.
All right. Now, the second part of what he talked about, I want to make sure you understand that's not waivable. The court is required. Let me start over again on that. Whatever the jury does, if they recommend the death penalty, which of course is much more likely if you don't present anything and you don't make any argument, I still have to make an independent determination whether the death penalty is appropriate or not. And Mr. Prince called that a Spencer hearing. I would require the attorneys to present to me whatever evidence they have gathered. That it's your decision here today, but at the Spencer hearing, that will not be your decision. I will require them to present the evidence to me. So if what you're trying to do is avoid it being presented in court, it's going to be presented at some point in time, because I have to make a decision also, not just the jury. Do you understand that?
Yes.
Does that change your mind about what you want to do here today?
No.
So you instructed your attorneys not to present any evidence, is that correct?
Yes.
And you've instructed your attorneys not to make any argument contrary to the death penalty, is that correct?
And or call any witnesses.
Right, and that's what you want to occur here today?
Yes.
And do you have any questions about what you're doing?
No.
Anybody pressured you into doing this?
No.
Anybody kind of made any kind of threats against you to try to make you do this?
No.
This is your own personal decision.
Yes.
State, wish to make any further inquiry?
No, Your Honor.
All right, thank you, Mr. Segura. All right, so with that, I will find that his waiver of mitigation is freely and voluntarily made. We will proceed with the jury. What do you anticipate saying to the jury in terms of a opening statement or a closing argument? What's going to be said?
That we will not present an opening statement or a closing argument, Your Honor.
You're just not going to say anything at all?
Correct.
Okay. State, have any issues we need to raise before we start with the jury?
Your Honor, I guess procedurally, how we need to address it we need to introduce these exhibits, and I don't know if we're going to do an opening, do we need to close it, or just do one argument that is?
Well, that'll be up to you. I'll offer you an opening. You can make it or not. I'm going to offer it to the defense. Apparently, they're going to decline. Then you present any evidence you wish to present. They're going to be offered the opportunity to present evidence. Apparently, they're going to decline. Then you're going to be offered an opportunity to make a closing argument. You can make it or not as you see fit. They're going to be offered opportunity. Apparently, they're going to decline. And then I will instruct the jury. That's how it will proceed. Now, of course, before we move to that, we need to have a little more discussion about jury instructions on the final part of it. But that's how things would proceed. Do you have an issue with any of that?
No, sir.
Defense have an issue with any of that?
No, Your Honor.
We're ready for a jury?
Yes,
Ready
Your
for
Honor.
the jury?
Yes, Your Honor.
Okay. All right. Let's have a jury, please. everybody be seated. Thank y'all for being back here today. We appreciate you kindly returning. I'm sorry we were delayed. We've been working. Don't want you to think we've been goofing off. We've had a couple of issues to deal with. I think you'll see this thing's going to move pretty quickly from here on out. I'm now going to give you some preliminary instructions as to the penalty phase. Members of the jury, you have found the defendant guilty of 4 counts of murder in the first degree. The punishment for this crime is either life imprisonment without the possibility of parole or death. The attorneys will now have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you're not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant will be given an opportunity to present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence, along with the evidence that you heard during the guilt phase of this trial, is presented in order for you to determine, as you will be instructed, whether each aggravating factor is proven beyond a reasonable doubt, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty, whether mitigating circumstances are proven by the greater weight of the evidence, whether the aggravating factors outweigh the mitigating circumstances, and whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence and after argument at counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is a standard to guide the jury in making the choice between life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of a crime or the harm to a victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond every reasonable doubt, and you must not consider it in providing your verdict on the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. Before moving on to mitigating circumstances, you must determine that the aggravating factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factors are sufficient to impose death, do not move on to consider the mitigating circumstances. Should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, it will then be your duty to determine whether the aggravating factors that you unanimously find have been proven beyond a reasonable doubt outweigh the mitigating circumstances that you find to have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proved beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as the sentence to be imposed. Next thing will be offered is an opportunity for the attorney to make an opening statement.